I'm the executive director of Letterbox Legal. And what we try to do is we try to offer legal services to independent creatives in a very different way than your traditional lawyers of the per hour scenario, right? So we do package deals, we do retainers, we work on a project basis more often. So for game and mobile app developers, we're usually helping them from when they design the game to maybe when they're doing crowdsourcing to get money for the game, everything to the end user license agreement or the click-through privacy policies, all those kinds of things that we work with them. Okay, but today we're going to talk about something, and somebody asked me, but you're a lawyer. And I am not going to discuss any of the technical things that deal with VR. I'm not going to discuss the software. I'm not going to discuss the hardware beyond what we're looking at in terms of the legal stuff to it. And as my disclaimer is, I have to start off with this, what I'm going to share with you is what we call legal general for educational purposes, but not legal advice, right? Everybody's going to have a very specific issue or set of facts, and for that, we recommend that you actually go to your attorney, okay? I like to have it a little interactive. You can see I move around a lot. That's from New York, okay? But as you have a question, please ask it at that moment so that we keep it within the context, right? Now, if I know that I'm going to answer it in a couple of slides, I'll say hold that thought. But if not, then we will answer it right then and there, okay? Cool? Good stuff? Okay. So this is who I am, the executive director. I'm a licensed attorney, both in New York and in Georgia. So I actually have clients in both places. My focus is IP, intellectual property, in media, technology, and entertainment. Now, I do not do patents. My sweet spot is the idea of licensing and monetization of creative endeavors, okay? But I do not do patents. And I have also written a book, Managing Online Risk, Apps, Media, and Social Media Security. Okay, so when we talk about the legal aspect of virtual reality and augmented reality, we're really looking at five, as you see here, 4 particular categories of stuff. The first one is consumer safety. We started talking about that a little, right? The idea, is somebody going to be safe using this kind of technology? And the second one is about privacy. A lot of times, not only do we have the virtual reality concept going, but now we have the idea that we can be social with virtual reality. One of the things that always held back virtual reality was the idea that you had to play it in isolation, right? Most people, when they play games, there's a big increase in the type of social games or people playing online. My daughter, for example, met her husband. They were both in the same guild in War of Warcraft. They've been married now 6 years, have a little boy, okay? There's that social aspect to gaming that VR sort of put a stop to that, and so it's one of the reasons why it wasn't adapted as quickly as some of the other technology. But when you do that, when you open it up, what happens to the data that gets collected? Because now it's being collected by a third party. What's happening to that? So we're going to talk a little bit about that. Intellectual property, okay? Who owns what when you're doing this? Most of the time, any kind of VR game, you're usually not working alone, right? You might be working in collaboration. It might be something that's done in the studio, or it might be something that you're doing with friends that you're putting together, okay? So we're going to look at who owns what. And then the First Amendment law, that freedom of speech. Okay, and very specifically, we had a couple of years ago, the Supreme Court who passed that judgment that said, you know, violent video games are actually protected under the First Amendment. And we're going to see how that plays out in some of these aspects to it. So let us begin with the consumer safety. Yeah, Pokemon Go. How many of you played Pokemon Go? Do you play it anymore? Was it just passé, right? That was a big thing down in 2016. But unfortunately, the lawsuits are still going. Even though the game is over, the lawsuits are still going on Pokemon game, mainly because of things like this. Men fall from cliff playing Pokemon, or this young woman who actually found a dead body while she was trying to hunt a water Pokemon and found a dead body. But what these articles, and there's a link there if we want to play it, we can play it a little bit later. was talking about this idea that when people started working or playing Pokemon Go, they got so immersed in the game, even though it was augmented reality, right? Different than the virtual reality that takes you there. The augmented reality sort of put something on top of the real world that were there, but people got so caught up in it, they were walking in the middle of the street and getting hit by cars. They were crashing their cars. We have a gentleman who crashed a car right into a tree because he was playing Pokemon as he was driving. There were a number of trespass concerns, right? People who, there was one young man in California who kept getting knocks on his door saying, "Can we go to your backyard because there's a Pokemon?" And he's like, "What are you talking about? You're not supposed." Or people who just went into the backyard without knocking on the door. And so that became a big deal. And that actually became a class action suit against Nintendo of people saying, you know, you had no right to put those GPS locations of my private property in your game because you are, in fact, enabling, right, encouraging people to trespass on my private property. That was an $18 million lawsuit, and believe it or not, still going on, hasn't been resolved. But all of these things that sort of came out because of this desire to just be playing and brought up the ideas of, you know, this distraction from just being aware. But I think it also brought up the idea that you didn't need the headset to be completely immersed in this kind of experience, that this proves what? That even the augmented side can totally take you into that. So let's begin, and I'm going to begin with the hardware and software in terms of those legalities. Because when we talk about virtual reality, we have the hardware, which could be the cardboard box, or it could be the Oculus headset. And then we have the software that actually creates the virtual reality shorts or plays the virtual reality shorts. And then we have the people, the users, okay, and the developers. So we're going to start with patents. And we had a big case going on. Facebook lost this case. Does anybody know what that case was?
Was it the mood experiment that they did?
No, it was not. It's really focused. Oculus versus ZeniMax. And Facebook owns Oculus.
Oh, yeah.
The Oculus Rift, it was a $500 million suit that they lost. ZeniMax did win. And the idea there was something called trade secrets. Now, what's interesting about trade secrets is you don't register trade secrets, right? If you register trade secrets, it wouldn't be a secret anymore. But the idea of trade secrets is something that is proprietary information that you disclose in a way to somebody who's helping you work on a particular project. And ZeniMax claimed that the person who had created then the Oculus Rift had taken the trade secrets from what he had done with ZeniMax, and that's what allowed him to then put out the Oculus Rift. Now, it's interesting if you read about the young man in question, and I have his picture here. So when it first came out and Facebook said, you know, we want to buy this from you, they paid him $2 billion. Right, that's a lot of money. But they thought that this was their way of getting into the VR scene. He has not been heard. We don't know what he's doing at Microsoft, at Facebook anymore, but he is still there, employed, but he's costing them a lot of money. Okay, but in business terms, you can say, okay, I paid $2 billion, now it's another $500 million. How much money are they making off the Oculus Rift, though? They might be considering that as just another business expense, whereas that might bankrupt a small company. For Facebook, it does not, right? Now, Facebook has said that they will, in fact, appeal the decision, okay? But it was interesting how they did it based more on trade secret than the actual patents that were filed for each of these technologies. The other thing that the court says is that, okay, so when you get a patent, it has to be something novel. It cannot be something that has been created before. Okay, that's a problem because most of the time technology is built on other technology, isn't it? It's incremental, right? Every time you do something, then you're able to work from that to get to the next one, which means that whoever has the base patent will be getting money for life, right? Because every time somebody wants to build a patent on top of it, they have to pay for the patent that's before it. Patents last about 17 to 20 years. It's basically the government giving that developer a monopoly for 17 to 20 years where nobody else can use that technology unless they license it. So you can see patents are very expensive to get, first of all. They take about 3 years to get through the process. And it can take $30,000 just to do what they call the prior art search. And prior art search just means that they go through the entire database of patents and make sure that what you're claiming hasn't been claimed before. Okay. There's also something called a provisional patent. It's a lot easier, a lot cheaper, but it gives you some protection for just 1 year. And basically you're saying, you know, I want to get this provisional protection because I'm actually going to file the patent within a year. I just need some more work, some more time to get through the prior art search. Okay. So very expensive, takes a lot of time, but what you get back after you go through that process is also worth a lot of money, right? Because nobody else can then touch it. Yeah.
My question is say you have the patent and then somebody infringes on it. How much does it cost to protect yourself against? That's more money to protect yourself.
It absolutely is, yeah, because you have to get a lawyer, you have to file it in a federal court against this person. So you go through a whole trial, and you have to prove, one, that the patent is yours. If you have a registered federal patent, that is what we call, per se, evidence, prima facie evidence. And the court will assume that you own it, right? Because you have a federal patent. They will make that assumption on your behalf. But the person who is doing the infringing then has to prove that that patent is invalid, right? It's on their end. It's on their end. But you also have to prove how they infringed it. Okay, you have to bring that up as well. Any other questions? Yeah.
Patents are territorial, so if you get one in the U.S., you can still make it in China, and then you have to prevent that item from entering the country. So, I mean, how do you do that?
Yeah, so we do not have international intellectual property rights. Now, we have treaties like the World Intellectual Property Organization, WIPO, not WIPA, WIPO, WIPO, and we do have some treaties that say that countries will recognize the intellectual property rights of others, okay? But if you want protection in a particular country, you have to file for that protection in that particular country. China is notorious for infringing and stealing, and I don't know if you remember about a year, maybe 2 years ago, then President Obama actually had a meeting with the Chinese prime minister, and that was one of the things that he was trying to get the prime minister to sort of agree to, that they would actually, bring down that idea. But it is very difficult in that. There's also something called the Madrid Protocol. But the Madrid Protocol is more for copyrights than it is for patents.
Trademarks, too.
Yes.
This may be kind of a rookie question, but what if two people kind of come up with the same thing at the same time independently? Because I know that can happen just because people are working on the same, two people may have the same idea at the same time, and it's not anybody stealing from anybody else. It just happened to happen.
So under U.S. law, that's valid in copyright, but it's not valid in patents. In patents, it's the first one to register.
So if you don't beat the other person to it, you're just screwed. Ouch.
Race to the patent office.
Yeah. Yeah. Okay. So Oculus versus ZeniMax also brought up some copyright issues. Now, copyright is the protection of intellectual endeavor. And a couple of things to remember about copyright is that it does not protect ideas. What it protects is something that is fixed in a tangible format. Okay? So if we look at games, for example, how many games are about chasing something down? How many games are about shooting something down, right? That you can't protect that idea. What gets protected is how you actually shoot them down or how you chase them down. Do you do it with cars? Do you do it because there's zombies there? Do you do it? You know, those are the aspects that can be protected. And those aspects come across in what? The code, okay? So this is actually about protecting the code, the actual programming of it. And that's what gets sent to the Copyright Office. But also some of the visuals, right? Because a lot of these games, if you don't have a visual, it doesn't really make it, does it? I mean, I'm old enough to remember those DOS characters being formatted. Do you remember those? Okay. And you can make the little thing dance or stuff. I mean, very, very primitive, right? Or the kind of games where you typed in, okay, go to this mountain and pick up the sword. And then they say, sword picked up. And then you go back, okay, wave the sword at opponent. And it says, sword has been waved, okay? Can you imagine doing that today? No, right? Most people would say that's a very boring game. I'm not going to play it. So we need those visuals. So those visuals can also be protected by copyright. Now, copyright actually has 5 different rights within it. The first one is the right to reproduce it, right? To make multiple copies of the game that you do. The second one is the right to what we call a derivative work. Okay, so think of movies, for example, and from the movies, what do we get? People start making games based on the movies, right? So think of how many games are out there for Harry Potter. And then we have the reverse. We have a game that becomes a movie. World of Warcraft was one of them, who then became a movie. Each of those is a derivative of the original. It means that we can make something from the second. So you have that right to create something from an original when it's your copyright. A third right that you have is the right to distribute. Okay, and you want that right. That's how you make your money, right? If you sell it and you get people to pay for it, that's how you get your money. So you definitely want that right. There's a right of display or performance. So think of that. In our online world, that would be our right to do what? To stream, to have people play it right online with each other, okay? So there is reproduction, derivative, distribution, display, and performance, okay?
So what about YouTube and Twitch streams then? Because they don't work for the company, but they're streaming it online
Yeah.
and performing it, and this is a very widely known thing.
Yeah. Now, when they are streaming, right, can anybody else play that game through them?
Sometimes, it depends on the game. There are some games where they can like go on and join with them, like,
Go on and join, but they can't be that one person who's playing, right?
no.
So that's the difference with that. Not only that, the companies like having the exposure.
Yeah, so they're
Okay,
just
so-
not- they could fight them on it.
Oh, absolutely they could,
Okay.
right? But most of the time they don't. They'll actually pay or give them free software
Yeah.
and say, play our game and go on Twitch and show it off, right?
Yeah.
And they'll do that.
Was this case a copyright case?
It was a piece of a copyright case.
Because that technology would more fall under patents. wouldn't it?
The technology would, but the code would not.
But the code is just implementing the technology. It's not an artistic work. I always thought copyright had to do with artistic works and patent had to do with inventions.
Not necessarily. For copyrights, you can have something very technical. A technical handbook could be copyrighted.
Has been notorious for patenting code. So I'm surprised to see
Mhm.
this case being a copyright case. But copyright, you'd much rather have copyright than you would patent because it's what, 95 years for corporate copyright?
Yes, and 70 years if it is a human individual. And we got that thanks to Sonny Bono. If
Yes.
anybody remembers who
Okay.
Sonny Bono is, it was called the Bono Act. And basically, what happened, copyright used to last just 50 years.
It's next to Mickey Mouse.
And Mickey Mouse, there's a particular clip of Mickey Mouse called Steamboat Willie. And that was going to go into the public domain. That's when the copyright expires. That means that everybody could have Steamboat Willie. Well, Disney did not want that. And so they had Sonny Bono introduce the Bono Bill. And their claim was that it would make it as long as in Europe, and therefore we can be more competitive if we had the same length in copyright that Europe did. So Congress accepted it, but Congress did say with a caution, we will not extend it again. So now,
2023.
now if you go to any video of Disney, any showing of Disney, the first thing they show is Steamboat Willie. And every time they show it and make a little modification to it, they renew the tolling of their copyright.
Really?
Yep.
But the copyright's on Mickey Mouse himself. I mean, if they lose the copyright on Mickey Mouse, people can put Mickey Mouse on their,
But they've also trademarked Mickey Mouse.
Oh, that's
They've
right.
also trademarked Donald Duck. They trademark, so it's not just about copyright. One of the things that you'll learn about these rights is that they're used in connection with each other. One does not necessarily invalidate the other.
But how many trademarks can you have for your company? I mean,
As many as you apply and they give it to you.
really?
Yep.
That doesn't seem right.
I don't know, I mean,
Because that's, a trademark is sort of a representation of your company. isn't it?
Yeah, so a trademark, which is our next one, is about identifying a source in commerce. Very different from the copyright, which is just protecting that intellectual effort, right? But a trademark, you have to prove that you're using it to identify yourself in commerce, meaning it has to be in business. So this is the website We Are VR. We ARVR. And on this website, what you notice is that there's all of these sample VR games that are out there. And one thing that has happened is that there are games like Harry Potter VR that have not in any way been licensed by Warner Brothers or by Scholastic, right, who is the publisher of the Harry Potter games. And so there's been some legal disputes as to whether they can even do that kind of thing. And one of the arguments that these developers who put up these games are saying is that, well, the reality is we're not making money. And does it in any way affect what the money that you are making, Warner Brothers and Scholastic? Okay? So that's the idea of trademarks. And we have different kinds of trademarks in games. So you can have a trademark on the name of the game. Okay? You can have a trademark on your company name. You can have a trademark on the particular characters in that game, or a trademark on a particular city that you might have in that game. Okay?
oh, we were just talking about this on the way down. Like, what about, so, and of course, part of the question is if you've got like just anonymous people on the internet, like basically turning one of your trademarks into a meme. Like we were talking about Pepe the Frog, right? And so, first of all, how do you track those people down? And second of all, is there protection for like, because they're portraying Pepe and like associating him with a political stance that the creator is not comfortable with. Where are the protections for that kind of thing and for reinterpretations of characters that the owners do not want?
So that is a great segue to what we're going to talk about. Those kinds of issues, copyright, trademark, and First Amendment rights, or the idea of being able to use somebody's character or trademark to make a political statement or a community comment, right? So under these rules, there is something called the fair use doctrine. And the fair use doctrine says, you know, there are certain situations where, yeah, even though somebody's copying, there is a justification for that copying, and we are not going to ding them. We're not going to penalize them. Social commentary is one. Parody and satire is another. So parody is making fun of something, right? Weird Al Yankovic, his whole career is based on parody, okay? Satire is when you make fun of somebody's failures, Okay, so a lot of the GIFs coming out right now are more satire than they are of parody. And there have been a number of brand owners, trademark owners who come out and say, I don't like the way you're using this. And the courts have said, no, it's about social commentary. It's okay. The key to those cases, though, is that people have to recognize the original. If they don't recognize the original, it's like they don't get the joke, so the joke isn't valid, right? The court says people have to recognize it. So you have to be kind of true when you're making that copy so that the court can say, yeah, we get it, okay? But there are times that they don't. So, music, for example, is one that has been hit pretty hard. I told you about Weird Al, but we also had political candidates who took music and then put different words to it. And that, the court said, was not First Amendment, because you're not really taking the song in its entirety to make fun of it, right? You're using it to make fun of somebody else. So they don't accept that.
So the four criteria for fair use under copyright also apply to trademarks?
It does not wholesale, but what we're seeing is that the courts are starting to listen to arguments. So the other piece that I wanted to bring up in terms of Pepe the Frog is the idea of delusion of trademark, okay? Where value of the trademark is diminished because of the way that it was used. And you talk about Pepe the Frog, I'll go back to Mickey Mouse. There was a t-shirt that was being sold on the streets of New York that had Mickey and Minnie doing it all different positions. Okay, now you can imagine that Disney was not very happy with that. Okay, these are its two sacred characters, and look what it's doing on it. And so the other thing is Disney is extremely litigious, so you should just know that. Don't do anything with don't. It's not worth it. It really isn't worth it. But they came down hard, saying, "Hey, our audience are children." Okay, and what they're doing is they're diluting our trademark in a very bad way. So, but that's an extreme case, right? That's an extreme case on that. But how many singers and brand owners that we have that are saying, don't play my song in that? They have no control over that. They can voice their opinion that they don't want their song associated with something, but they have no control over it. Once the song is out, as long as the royalties are paid, it's out. Okay, so that's the idea of trademark. And the four factors, in case anybody wants to know about fair use, number one, they look at what exactly was copied, right? How much was taken? Was it the essence of what was copyrighted, or was it just, something minor? So we had an interesting case with streaming where a man on an island in the South Pacific actually live streamed Facebook Live the birth of his son. And the morning show, Good Morning America, took a clip and showed it, right? They didn't show any of the bad stuff, right? But they showed a clip saying, hey, this man, live streamed Facebook Live the birth of his son. And then he sued for copyright infringement, saying, hey, that was my video. You didn't have any right. And, the court threw out the case, but the arguments were basically like, they showed 22 seconds out of a 45-minute video. You had already put it on Facebook Live, and your Facebook account was not password protected. It was set to public, meaning that anybody could see it. They knew that over 120,000 people saw it right as it was happening. Okay, so there wasn't really much for him to claim, and the last thing was there was no harm. What harm did he experience? I would think more his wife has a better case of saying, hey, how could you put me up there as I'm giving birth, right? But he himself really did not have harm because 22 seconds of that clip. But that case was thrown out, okay? But it just shows you how these things sort of work together. So here's another one. We have a lot of reality stars, don't we? People who go on a particular show and a few minutes later, they're just famous for something. And this was a 14-year-old girl. She was 13 when she showed up on Dr. Phil's show. And she made a couple of statements. One was, "Call me outside and doom da ba," or something like that. And then we had a game company who created 2 games based on those phrases. Okay, And so she sued, saying, you know, I have a trademark protection in those phrases, and you just can't create a game using that without paying me. Now, there were a couple of problems here. One was that she had never registered for a federal trademark. Okay, so that was one issue. But there is something called a common law trademark, and most states will have this. If you start using a mark, you can actually put a little TM in a circle at the bottom of the mark because you're using it. Trademark applies the moment you start using that mark in commerce. Okay, so the moment you put it out on your website, the moment you put it on your business card, it is already there. But what the difference is, you get very limited protection. It's only good within that particular state. Okay, whereas the federal trademark, it's protection throughout the U.S., not the world, just the U.S., right? So there are differences. So one of the problems with this case is that they said, you know, you did not register for the trademark until X amount of time before you filed this case. And so it's not, it doesn't really help you in that. And most courts want to see a federal trademark. The other thing about trademarks that I find interesting is it relates to domain names and social media account names. You know, it used to be, if you're thinking about a game and you're thinking about a title of a game, it's just the title of the game, right? Now you have to think of what? The website domain name, the Twitter account, the Facebook account, the Instagram account, the Snapchat account, all these things, and you want to make them as what? As consistent as possible. And it gets very difficult to pick a name on that. The other thing that makes it difficult is like Twitter and Facebook, they have a lot of accounts that go abandoned. People that might set them up, and then after a couple of years, they don't use them and they're just out there. There's a lot of them, right? I mean, Facebook has over 1 billion accounts right now with users, and Twitter in the millions, and they have actually put out a statement saying that they will not reassign those accounts unless you have a federal trademark. If you have a federal trademark, you send them the federal trademark, and then they will give you the account of that federal trademark if it's abandoned. Okay? So I've done that for a couple of clients, but other than that, there's no way to get them to release those abandoned ones.
What constitutes it as abandoned?
That it hasn't been used in over 2 years. So on Twitter, that means there isn't a tweet. On Facebook means there hasn't been a post, right? No activity for 2 years.
What about a login?
Depends what have they done with the login, right?
They logged in and didn't do anything. Which is
Well, there's the argument that waste. So the idea here is that if they don't do anything, they're wasting that space.
So if you're a lurker, you don't deserve to have an account?
What do you think?
I think you deserve to have an account if you're a lurker. You're watching.
And there will be some states that will say just the login is enough activity. There'll be other states that say no, you need to be a little bit more proactive than just having the account there.
What about domain names? What about if they are abandoned? They're sitting there and not being used.
Yeah, so sometimes if it's just the domain name and there's not a website, so that was for social media accounts. The website, the only thing you can do is try to buy it from them because a lot of people will just buy and hold. Okay, now this is different from what used to happen about 10 years ago, cyber squatting, right? The idea that people would buy like Coca-Cola.com and say, okay, you need to pay X amount of dollars for it. And now what we have in the domain name space is what they call the trademark clearinghouse, where if you have a federal trademark, you can actually register it with the Internet ICANN trademark clearinghouse, and any time that a new domain level comes out, like when XXX came out, okay, this is how this all started because Disney did not want Disney XXX. So they set up this system so that you can register your federal trademark, and then anytime a new domain level comes out, you have a grace period to buy that domain level before anybody else. Now, it still means you might have to pay a couple $1,000s, but you get the chance before anybody else does. So you can see how trademarks have actually increased in value because of the online. Do you have another question? No. Okay. Okay. So Then we have what are breaches of contracts. So anybody here who's a developer? Have you signed a contract ever? No. Okay. Sometimes if you work in a studio, right, they might have an employment agreement that you've signed in the beginning. Sometimes if you're a freelance independent contractor, they might have you sign an agreement right before you start the work as to what kind of work that you want. And these agreements are very important for a couple of reasons. Number one of the things that they explicitly state is who owns the intellectual property of whatever is created. Now, in an independent contract, well, let me start with the employee. If you're hired as an employee and given an employment agreement, anything that you create within what they call the scope of your employment belongs to your employer. Does not belong to you. It belongs to your employer. An independent contractor is a little bit different. If it does not explicitly state in your freelance contract that this is considered a work for hire and that you grant and transfer and assign your rights to the intellectual property, you still own it. Okay, and this has led to many, many lawsuits of companies saying, I paid that developer $1 million, it belongs to me. It's not in the contract. That developer still owns it.
Would that side be covered with an NDA non-compete?
Nope. So a non-disclosure, non-compete is very different. A non-disclosure is about keeping information secret or confidential, okay? A non-compete is usually about that you cannot, well, there's a non-solicitation, which means you're not going to go after their customers, right? If you want to set up your own company, you can't go after that person's customers. That's a non-solicitation. A non-compete means that you're not going to do the same work for somebody else within a certain radius. Now, if you're a freelance contractor, you never want to sign a non-compete because you want to work for everybody. Right? And Atlanta can be a small place. 50 miles can be pretty big when you're in a city downtown. Okay? So as a freelancer, that does not benefit you to sign something that says you cannot non-compete. You're a developer. You're a programmer. That's what you do. You know, you have to be able to do that. So you have to be careful about those. Another thing about the NDAs, so there are different viewpoints about how effective an NDA can be, when you should bring it up in terms of a negotiation. I always tell people, you have to know who you're talking to, right? Because a lot of people, they don't want to sign an NDA and get locked into something that might not be a valid project to begin with. Okay, so you want to be careful about those, because some people will just say, you show me an NDA, I'm out of here. I won't even take your meeting, because I have to know what it is before I can go further. So if you're going to be talking to people without an NDA, just be careful what you say. Don't give them the secret sauce yet, because they didn't sign off on it, okay? And you never bring it at the first meeting. It's very difficult for people. So let's say you've signed a contract and it has a confidentiality clause. Confidentiality clauses do also mean you can't post it on Facebook. You can't post it on Twitter. You can't do an Instagram. Hey, look at me. I'm at High Res Studios today. Look at what we're doing. If your contract said, you have to keep it confidential that you're even working here. Because there are contracts that read that way, that they don't want you saying what you're doing. Especially in entertainment, for example, this whole thing about leaks, right? So think of in the gaming industry, if there's a game that's going to be released and it's a really big thing, but they don't want anybody to know about it, a leak can mean a breach of contract, okay? And usually what they'll have in the contracts is they'll say what will constitute a breach of the contract, what happens there, and then what remedies. If you breach the contract, what remedies does that company have? Okay, theft of IP. So not only do you disclose it, but then you take it with you. And as you see in the Oculus, right, the trade secret, so much gets released on Facebook. And I usually tell people, Facebook does have in its terms and services a clause that says to use Facebook, you are granting to Facebook a worldwide unlimited license to use the data that you put up there, not only for them, but that they can share it with their third-party affiliates. Okay? So they don't claim that they own it. They just say that you're giving them this license to use it. And they can use it in any way, so you want to be careful about that. And usually the story that I tell, even though it's funny, but it's not funny, is one of my clients who was on Facebook, looks on the side, there's an ad about, you want to date hot singles in this area. He looks there, it's a picture of his wife. He goes to his wife, he says, hey, what are you doing? What's wrong with our marriage? What's going on? She's like, I didn't do anything. No, Facebook just picked it up and they used it. So, almost caused a divorce there. So you got to be careful about what you put. And so what I tell my clients a lot is use social media as teasers, right? Put just a little bit. Don't put your whole song there. Don't put the whole game there. Put a little reel, put a little sizzle reel, or put a little trailer. But the key is get them back to your website because you control your website, okay? But you don't control what they will then do on Facebook and Twitter. So you want to be careful about that, okay? So theft of IP. Besides that, very taking out of it, anybody here use Pinterest? You may remember Pinterest sometimes. Okay. Well, when Pinterest, this electronic bulletin board, right? It's the idea that, we usually save things, put it on a bulletin board. Now we can do it electronically. One of the things that came out when they first came out was this idea that what you're actually doing is copyright infringement because you're cutting and pasting things from other websites without anybody's permission. And then they came back and they said, but we're giving them credit. We're showing the link. Copyright is not about giving credit. Copyright is about getting permission to post it. Okay? So what did they do? They got Google's head lawyer, hired them to change their terms of service for that. So if you, though, as a developer on your website have that little Pinterest social button that people can then pin from there, you are basically giving them permission to take your IP. Okay, of anything that's on that website, if you have that little button there. So if you don't want them cutting and pasting, take the button off. Okay, it's okay to link to something else. It is not okay to cut and paste. Yes, and then I'll come back.
What about feeds? Like you have feeds from different sites to deliver articles.
Yeah, so those are RSS feeds, and you've given what? Your email so that you can subscribe to it, and that website set it up as a subscription to send you that article, right? But it's a personal read type of situation. They're sending it to you. You're that individual person. They are not giving you permission to then cut and paste it on your website wholesale.
What if it's on cut and pasted? Well, maybe I shouldn't talk to you afterwards.
Okay.
I have a specific question.
What about the redirect ads that you click on my link, but it takes you to an ad
Uh-huh.
that's contrary to what you've been redirected to? You have control over that.
You do not, to a certain extent, right? So when you click on something, anybody here remember when there used to be a lot of framing on websites? Like you click and you go someplace, but it'd be framed in there, okay? So that's considered a no-no for many, unless it's in their actual terms of service where they say, because you're part of our community, we're going to frame if anybody clicks to you through us. But that's on the terms of use in that. But getting back to your question, when a banner ad comes up or when a pop-up ad comes up and somebody clicks on it and they take you somewhere else, that's not the website owner, right? Unless you are selling the ad. So we do have something called a safe harbor rule for internet service providers. We got it through what's called the Digital Millennium Copyright Act. And what it says is that basically channels, right, are not liable for what end users put on their channel. So this is how YouTube gets away with a lot of things because they're saying it's the end user who puts it on, it's not us. And so under the Digital Millennium Copyright Act, there's something called a takedown notice. If you find your stuff on YouTube, you fill out a little form online and say you need to take this down because it's copyright, I own it, and I did not give them permission to put it up there. What they do then, and you have to be very specific, so you have to give the URL of where it shows up because they're not going to go look for it. You have to give it to them. They will then send notice to the person who put it on there and say, hey, we're taking this down because we received notice that this is in copyright infringement. You have 30 days to give us proof that it's not. And most people, they just won't put it back up again. So that's why sometimes you'll get to a YouTube and it says this video has been taken down for copyright. That's what it is. Okay? But those are the safe harbor rules. Okay. So now that we've done the technology part of it, let's look at some of the actual content that we go through this. And this is probably one of the biggest issues is publicity rights, because one of the things that VR also gives us and augmented reality gives us is this use of avatars in a different space. And we were talking earlier about, as this software gets more and more sophisticated, things become and look more and more real. Now, EA has had a slew of lawsuits that deal with the right of publicity of sports figures, for example, in their Maddox and stuff like that, saying, well, we have a First Amendment right to use their image, and the players saying, no, that's a publicity right. And a publicity right is basically the right of each of us to make money off of our image. Okay, and it can also be our voice. So we have a very famous case where a company, Mercedes-Benz or BMW, wanted, I can't think of her name now. I think it's Barbara Streisand to sing a particular song for their commercial, and she refused. She turned it down, and then they got a sound-alike, someone who would sound like her, to sing it. And she sued, saying, hey, that's my right of publicity because you hired that person only because she sounded like me. And she won the case. Okay, so rights of publicity are not just about the way the person looks. It could be another attribute that is identifiable to that person. And in most of these EA cases, what the court says is, first of all, you're taking an exact rendition of that player. Okay, you're making that avatar look exactly like that player. You're putting that avatar in an environment that's a real environment. That player would be on a football field, okay? So you're not taking him and putting him on a unicorn, right? You're not taking him and putting him in fantasy world. You're taking him into where he would usually be, okay? And one of the selling points was that people wanted to have an avatar who was a particular player. So even though EA came out and says, yeah, but we have a customization mode, meaning that you can take that avatar and you can change it up. You don't have to use that particular rendition. And the court said, yeah, but most people, when we go and look at how they're playing the game, they're keeping the avatar as is. They are not customizing it. So just having that feature did not protect them. It was about how did the gamers use the feature? And if they didn't use the feature, it was as good as not being there. Okay, so that's the idea of rights of publicity.
What if you use somebody who's dead? Like I make a baseball game with Joe DiMaggio.
Now that's interesting because rights of publicity are state specific. And it depends on the state that they were the resident of when they died. Okay, so I will give you a very cool example. Marilyn Monroe. Okay, you see her everywhere now, right? Because unfortunately, when she died, she was a resident of New York, and New York does not have a right of publicity that extends beyond death. But Frank Sinatra, who was registered as living in New Jersey, right next door, when he died, they do have a right of publicity that extends after death. And so his estate makes a lot of money. Michael Jackson's estate makes a lot of money, okay? But poor Marilyn Monroe does not. So it all depends on where they were actually registered to live.
Who owns the rights after you die?
whoever, those are what we call inherited rights and could be by the estate.
Come to the next stage.
Yeah, make sure you do,
before
right?
they die.
change their driver's license, make sure they're registered to vote in that new state. Believe it or not, but this is something that entertainment attorneys counsel their clients,
Yeah.
right? So when you think of, oh, but they work in LA or they work here or they work there, but their house is in Delaware, why? Okay, those are some of the reasons why, because the laws do differ. Okay, so that's our right of publicity there. Okay, so now, yeah,
Just really quickly, so it's okay if you are forced to customize it into something different, then it's okay? You do that?
if you're forced, right?
Like if you're in the onboarding process, you have to pick and choose and make a selection.
So that it depends though. I know I'm the lawyer, I have to give those kind of answers. It depends. But a lot of it depends on how you do it. So I'll give you another example Guitar Band and No Doubt. Okay, and No Doubt had a license with Guitar Band that you can use our avatars in this particular way. But what happened, the programmers with Guitar Band actually allowed users to use those avatars in other ways that were not specified in the contract, and so they lost that case very much. So you have to be, it's a very specific when you're dealing with these celebrities, because they don't want users to be able to do anything with them. Okay, they want to control their look, right? And what happens to their avatars. Okay?
So you just don't want to touch it, essentially.
Not unless you're going to get a license with them, right? If you have a contract with an individual, because sometimes some celebrities do want to be in a game, but they want a piece of it, right? And they want some creative control as to how you use them. So you can always negotiate to have them in the game. But I think you have to be very careful about just saying, okay, I'm going to take them and put them right in. Okay. So we were talking about how sometimes things happen in virtual reality and users get hurt, right? And so this is just something that's coming up, tripping over wires, accidental TV wreckage, and nausea. You know, you can get you hurt. How do you get prepared? There was a very interesting YouTube video that I was watching the other day where the girl with the Oculus Rift was on. She's playing, she falls, she dislocates her knee. Now, what was interesting is as the paramedics are there putting her on the stretcher, there's another guy still playing with Oculus.
I mean, did he not know that it happened, or was he just like, I don't care, I'm going back to my game?
We don't know. We don't know. It was just the visual of here's the guy, you know, playing with the Oculus, and here's the visual of the paramedics taking this girl out, you know, and he's just playing. But it is the idea that things happen. Does this mean then that that VR company is liable for what happens to people, right? So we were talking about the Pokemon situation where the guy, you know, crashed into the tree. Okay, is Nintendo liable because the guy crashed into the tree because he was playing Pokemon Go?
Is Samsung liable if you're talking on the phone and texting while you're driving and you crash? Where's the level of people doing stupid things?
Yeah, and there are questions about when do people then become accountable for the things that they actually do, right? And so these are all things in autonomous vehicles that we were talking about before is also something where this is evolving. Okay, this is all evolving. It hasn't been settled yet because there is the idea of what? Contributory negligence or the assumption of risk. If I say, you know, I know that this can happen, I'm responsible for it. Now, there are new apps that are coming out. So, for example, there's an app for the phone where you can put it on and it will not allow you to make a call, will not allow you to accept a call, will not allow you to even get to your GPS, which sort of defeats the purpose sometimes when we have our phone. But there are technological solutions that they're trying to put in place to help people resolve. So we're getting short on time. I just wanted to bring out a couple of other game-related cases. I thought this one was interesting. This is a 64-woman old woman sues over destroyed virtual item worth about $28,000. So apparently in this game, very famous in Korea, you can enchant an item. And so she had a very rare item. It was a sword. But the problem is if you enchant it and it fails, you lose the item. Okay, and so she claimed that she had tried to enchant it. She lost the item. It was worth $28,000. She asked the company to give it back. The company refused, and she sued. And the court came out and said, you know, but as we look at her log, as we look at her game log, we see that she kept enchanting other items, right? So even after she lost that item, she kept enchanting other items. And so they said, no, you know, you made a mistake. It's a user mistake. The company is not responsible for it. So they did not allow her to take that. Yes, that's the Korean courts. Okay, millions of game accounts exposed in data breach, responsibility thrown to the wind. You've probably heard this, the Sony game account. And this is another thing. As gamers become social, as we start connecting, the value, and I had said this about a few years ago when I did a session on social games, the value is not in that sole gamer. The value is in all the connections that that gamer has. That gamer, in essence, becomes a hub. Okay, so that's where the value comes from. And so when we have a breach like this, what are the responsibilities of that company in order for the breach in terms of protecting that data and making sure that it does not go through? And so we have all sorts of data breach notification laws by state, as well as we have some by federal. So if you are doing a game and you are collecting information, there are certain responsibilities that you're going to have about that information.